Hello, everybody. How's it going? Is there anybody here? Don't know. Let's see. We are live in the office. It's 4 o'clock. This is the kickoff to Estate Planning Awareness Week. We're taking questions. We got some earlier that Courtney had solicited via her Facebook. So we'll answer those. And if you have any, there's a place you can write a comment on the page. So please feel free to write a comment down. Are we not, is it not up? Are you able to see it? It doesn't, I don't think it's working.
No notice on the screen. You are live, Mr. Defoe.
Oh, okay, we're live. Anybody watching? Okay, so.
You are live, Mr. Defoe.
Oh, okay, we're live. Anybody watching? Okay. I was watching. There seems to be a delay. Okay, so anyways, we got some questions here that Courtney has. What's the difference between a power of attorney and a durable power of attorney? Interesting question. So the word durable is used because powers of attorney used to terminate if someone became incapable of granting or having the capacity to grant the power of attorney. And so the durability is actually that the power of attorney will last beyond incapacitation. Next question I have here is the difference between a guardianship and a conservatorship. Usually, or maybe not usually, but generally you would go seeking both. The guardianship is control over the person, and the conservatorship is the power over the person's money. So conservatorship, money, guardianship, person, most of the time you need both, because if you don't have the conservatorship, you don't have access to their money. Now, with both guardianships and conservatorships, the easiest way to avoid them is to have a power of attorney, both a medical one and a financial one. Obviously have a durable one, like we talked about from the first question. But those will help you avoid the need for a guardianship or a conservatorship, and that can be a huge savings, because usually the powers of attorney are done as part of your estate plan. So even if we're doing a trust for several $1,000s, what you're going to save in not needing a guardianship or conservatorship is having to go to court and paying thousands of dollars to go to court to get the guardianship or the conservatorship over the person. Next question I have here is, what is a trustee? Trustee is the person that is in charge of your trust. They are the one that is going to be able to make the decisions when you're no longer able to. So whether that is during an incapacity, during your life, or after you pass away. At either time, the trustee, whether the successor trustee in this case, would take over, and then they would have control over all the assets that are in the trust. And when I say the assets in the trust, I mean your trust has to be funded for the trustee to have control over it. And that's one of the things we often work with our clients with, is to make sure that all of your assets are transferred into the name of the trust. Next question, and if you have any more questions, feel free to post them on our Facebook page and I will address them straight away. Next question I have is, what would happen if I don't have any documents done? So there's a number of things that happen, and we'll kind of take them in order here. This is a really good question to kind of explain the value of having your estate planning documents done. So first, we talk about the medical power of attorney and the financial power of attorney. If you don't have any documents done and you become incapacitated during your life, you're going to have to go to court and get a guardianship and a conservatorship for anybody to be able to help take care of you. And obviously that's going to cost money, because it's going to require at least one trip to court, and potentially anyone who wants to be the guardian or the conservator is going to be there, and potentially there could be people who object to it. Now, if you don't have a will or a trust, what happens? That is a little more, a little bit more interesting. So if you don't have a will or a trust, the law still is going to provide for the distribution of your assets to different people. And there's a set formula in the law. So, for example, if you're married and your children are the same, then the surviving spouse is going to get one half of, or they're going to get the first 150,000 and then one half of everything else. And if you have children that aren't the same, then they're going to get a quarter after the first 125,000. So it's going to be basically determined by the law and who the heirs are as to how much you're going to get. One of the other things, though, is they're going to look for at least 5 generations out who to leave the money to. So basically, surviving spouse, then children, grandchildren. If you don't have anyone else down that line, then they're going to go the other direction. So your parents, your grandparents, your aunts and uncles, your cousins, those are the people that are going to receive the assets. So if you don't have any documents, then that's who's going to receive it. Chris Riccobono joined. Good to see you, Chris. The next question is why does a family have to do probate? Easy question with an easy answer. A family has to do probate for a deceased loved one if there is no trust, meaning there's just a will or there's no documents at all. So the easy way to avoid probate is to have a trust. I see Courtney ask a question on the side that says, what is life care plan? A life care plan is a little bit different than an estate plan in that we're looking at how to help our clients age in place or live wherever they would like to, whether it be assisted living or in their home or in a senior apartment. So we're going to use a holistic approach. So Courtney's the elder care coordinator. And remember, tomorrow, 9 to 11, she's going to take questions. If you want to give us a call here at the office, 989-321-2330. You can call Courtney from 9 to 11 tomorrow morning and ask her questions. She's the elder care coordinator. That means she's the advocate for our clients everywhere. That isn't the law. And so I help the clients with a life care plan to do an estate plan. We do a power of attorney, durable power of attorney, durable medical power of attorney, generally a trust, although we can also do a will. We're going to help make sure all your beneficiaries are in line. But then we're also going to do a medical assessment and try to work with your accountants, your doctors to get everybody on the same page so that we have a plan moving forward. Obviously, there's things that can change as you get older, and we can't always know exactly what's going to happen, but we're going to try to put a plan in place which tries to account for some of those unknowns, but also then provides a plan for our clients. If anybody else has any questions, don't forget, post them on the right. Again, my name's Travis Defoe. We're doing this Facebook Live as part of Estate Planning Awareness Week, which starts today. Tomorrow morning from 9 to 11, you can call our office, 989-321-2330, and ask Courtney more questions. If you have about life care planning, like what does an elder care coordinator do? How can an elder care coordinator help us? And there's another question from Courtney on the side that asks, what's the difference between Medicare and Medicaid? And what can I have as assets if I have Medicaid? So Medicare first is medical, it's like medical insurance for anyone over 65. It doesn't cover long-term care. It doesn't cover assisted living. It only includes, the prescriptions, doctor visits, those kinds of things. So, well, we got another person joined. Welcome, Lenny. So Medicare is going to cover your health, but not necessarily your living situation. Medicaid, on the other hand, was originally intended to help provide medical care for those that are impoverished, and it has been utilized to help people pay for long-term care. Originally, Medicaid only covered skilled nursing facilities. We have a program in Michigan now called Choice Waivers, which allows Medicaid to cover assisted living costs if you qualify. The second part of the question is, what assets can you have to qualify for Medicaid? A single person can only have a house, a car, and $2,000. That's it. That's all you can have to be eligible for Medicaid. If you're married, it's a little bit more complicated and a little bit different. There's certain assets that don't count against you when we're doing Medicaid. And that's, you might have heard of people say they do Medicaid planning or they've done Medicaid planning. That's where you're looking at trying to move your assets around so that they're in qualifying type of assets that don't count against you. For example, you can do a pre-planned funeral and pay for funeral costs ahead of time, and that won't count against you for purposes of being eligible for Medicaid. So Chris or Lenny, if you guys have any questions, don't forget you can post them on the side, and we will do our best to answer them. Again, we're doing this Facebook Live for Estate Planning Awareness Week. It is, I don't want to say a holiday, but it's on the national calendar. And we're focusing today on questions for me, the attorney. Tomorrow from 9 to 11, Courtney will take questions via telephone. Call 989-321-2330 tomorrow if you have any questions about what an elder care coordinator does. What makes Defoe Law different from other elder law firms is a question Courtney asked. That's a great question. Number one, we have an elder care coordinator. We do life care planning, which and are a member of the Life Care Planning Law Firm Association, which is attorneys and law offices across the country. There's just over 100 different firms last time I looked at the number who practice life care planning. It was developed by an attorney in Tennessee, along with other attorneys, and basically it is a holistic approach to elder law. So we're not looking for our client to come in, do documents, do Medicaid planning, leave, and never talk to them again. What we're looking to do is build a relationship, hopefully ahead of time, and put together a plan, although we do crisis planning as well. But we're going to work with the clients on their legal issues, whether it be a Medicaid application and doing an estate plan. But then we're also going to help them with getting the care that they need, whether it's bringing it into their home. Courtney can help to help find people to provide the care in the home, or if we're talking about transitioning either into an assisted living or into a skilled nursing facility, we're going to work with you through that entire process to make sure that it's something that can be sustained over a long term. We want to make sure that our clients aren't moving every couple of months, so we're going to look at what it is that they can financially afford or what benefits are going to be available to them over the long term so that they can age in place wherever that is. And again, we're going to look at what are the, maybe the hurdles in the home. If we're talking about them staying in the home, can we do some construction? Can we make some modifications to the home? Or if we're talking about assisted living, we're mainly going to be looking at funding, but also, understanding what the client's disabilities are and what sort of care they're going to need in the long term. So, waiting for some more people maybe to come, but if no one else comes, I'm going to answer this last question and we'll see how things go. Again, thanks everybody for coming and checking out our first ever Defoe Law Facebook Live. We're doing this because of Estate Planning Awareness Week, trying to get everybody aware of the benefits of having an estate plan. And some of the downfalls we talked about earlier, the fact that if you don't have an estate plan, then you could need a guardianship or conservator, or also you might not have control over where your assets are distributed after your death. Courtney asks another question, says, what does it mean to have your trust funded? Very common question we get. Trust funding is a fancy way of saying that we have to take individual assets and put them in the name of the trust. So whether that means that we're retitling bank accounts so that the bank account says instead of Mrs. Joe Smith, it says Mrs. Joe Smith, the trustee of the Joe Smith Trust, or Mr. and Mrs. Joe Smith, trustees of the Mr. and Mrs. Joe Smith Trust, or maybe it's Joe and Jane Smith, trustees of the Joe and Jane Smith Family Trust. We want to make sure the bank account's in there, or sometimes we have IRAs that we may name the trust as a beneficiary, or life insurance policies that are going to be the beneficiary of the trust account. We're going to make sure your personal property gets transferred into the trust. Generally, we're going to do a deed or maybe a ladybird deed transferring your home into the name of the trust. So Again, trust funding is the overriding idea that we're going to move your assets into the name of the trust. So anyways, I wanted to thank everybody for taking a look at our first Facebook Live. Thank you, those people that came out, those people that shared interest. We're trying again to do this because of Estate Planning Awareness Week. If you have any additional questions, remember tomorrow morning, Courtney from 9 to 11 is going to take questions about elder care coordinators from 9 to 11 at 989-321-2330. Or if you'd like more information, please check out our Facebook page or our website. Our website is www.franklinslaw.com. There's a blog there that has a lot of good information. And you can also schedule an appointment right from our website or ask other questions if you want to send me an email. Again, thank you everybody for checking us out today. And we will, since we had some people show up this time, maybe we'll try it again. So again, thank you and talk to you later.